Okay, and good morning, everybody. Welcome to Wednesday's breakfast seminar. We are today lucky enough to have Jon Sharp, who's going to be giving us COVID-19 and the insurers' response, including all the updates from the last couple of weeks, which are many and varied. Don't forget you can submit your questions to Jon by using the Q&A facility in the bottom toolbar of your Zoom panel, and he will answer as many of those as possible at the end. As with all things, his details are on here, so if anything specific you want to ask him that he doesn't get time to address, he'll happily answer these via email for you. So without any further ado, Jon, I'll hand over to you, and we look forward to you sharing your wisdom with us. Thank you.
Well, thank you, Julie. Good morning, ladies and gentlemen. Trust that everyone's safe and well. I first put this seminar together probably about 4 or 5 days after we were locked down, and there's been a number of developments since then. I think that some of you may have seen some of this before, in which case apologies, but there are a number of new attendees, so I'm going to have to run through matters, and in any event it sets the scene for the latest updates which come towards the end. That's me. As Julie said, all the details are on the website, so I think the less said about him, the better, frankly. There are some caveats. I wouldn't be a lawyer unless there were some caveats. So this seminar addresses insurance issues generally. Everyone's policy does differ, and I can't possibly address them all. There are, for example, some 75 different versions of business interruption policies. However, I've tried to make it as accurate as I can, given the rapidly changing situation. But unless you email me directly, I can't address specific questions. But my advice would always be to speak to your broker, your lawyer, or your other advisor. We'll take a look at the agenda, if we may, and we'll look at Act of God, some general information about the virus, office policies, the concept of force majeure, concept of frustration, what the insurance market's approach has been so far. Have a quick look at mitigation and site closure. I'll touch on travel insurance simply because that's another reasonably hot topic. And then we'll look at the recent developments with regard to the insurer's response, and in particular, lastly, the FCA's business interruption insurance test case. At the beginning of this virus, there was a good deal of speculation in the press that this would be an act of God. Well, this virus is definitely not an act of God. There are two possible causes. There seems to be consumption of animals outside the food chain in China. And then, of course, you always have your conspiracy theories. Wuhan did apparently have the equivalent of our Pirbright. So it had a facility which stored viruses. And of course, the theory is that one of these viruses got loose, someone got contaminated, etc. Now, these conspiracy theories are still rife. Of course, they're encouraged by the lack of cooperation by the Chinese authorities in response to requests for an inquiry from the Australian government, the German government, and the United States. However, as said, it is not an act of God. The current law is set out in the decision of Lord Hobson in Transco PLC against Stockport Metropolitan Borough Council, which is reported at 2003 UK HL 61. And Lord Hobson described an act of God as an event which involves no human agency, is not realistically possible to guard against, is due directly and exclusively to natural causes, and could not have been prevented by any amount of foresight, plans, and care. This virus does not fall into that test. So what's known about the virus? Well, still very little. There's speculation that it doesn't respond well to heat, it doesn't respond well to alcohol. And various governments across the world have introduced consistent, reasonably consistent response to it, being containment, delay, and ultimately mitigation, cure. But no government, no matter where they are in the world, prepared for this, despite warnings. I've given you a link there to a speech that George Bush, who none of us particularly regarded at the time as being particularly good, but clearly is a genius compared to the current incumbent of the White House. He gave a very good speech and a little warning just at the end of the SARS pandemic in 2005 about what government should be doing to prepare for an outbreak. If you look back on it, we had an outbreak of a potential pandemic in 2003 and 2005, being SARS. Then there was MERS between 2009 and 2011. And there has been at least 2 other diseases which could have had a widespread impact. Yet no government anywhere in the world made full preparation to protect its population. Now, turning to insurance policies, I just want to show the distinction between a cover note and a policy wording. I still get this. I've done a number of talks now on insurance generally, etc., and it still seems to cause confusion. And it really is absolutely important that you know the difference between the two. This document is a cover note. It is actually this firm's business combined policy schedule. Yeah, but that's exactly what it is. It is a schedule, and in there it tells me what I've got covered for and how much I'm covered for it. It's a 4-page document. It's a nice summary, etc. It's like getting your cover note for your car. It tells you what you're covered for and how much you're covered for it. But it does not tell you the terms and conditions of your policy, because this document does. This is the policy wording that matches the cover note on the previous page. Now, this is a 60-page document. It clearly states that it's my contract with the insurance company, and it sets out detailed terms and conditions in relation to that policy of insurance. That is your contract with your insurance company, not the document on the previous page. Excuse me. So as I said, your covenant only identifies the main terms of your policy. It is not your contract with your insurance company. The policy wording is. This is your contract with your insurance company, and every year it should needs careful reading by the responsible officer in the company to ensure that it meets your company's requirement. And remember, it is a living document. People often renew their insurance policies and then simply put it in the drawer. It's not the way to approach it. If your business changes in any way throughout the year, including in particular taking on new or unusual types of work, you need to update your underwriters. So you need to regard your insurance policy, if you like, as a living document that needs to be updated throughout the year. To emphasize the importance the courts attach to policy wording, there was a case that I did back in 1990 called Kuwait Airways Corporation against Kuwait Insurance Company regarding Kuwait Airways losses as a result of the invasion of Kuwait by Iraq and the loss of their fleet. There was no policy wording agreed for that particular year. It hadn't been done yet. But the court said that doesn't matter. We will look at the previous year's policy wording. So I can't stress enough how important the policy wording is. Turning to particular types of policy which may well have been affected by the pandemic. First of all, you need to look at your office policy. Most construction companies, most organizations have an office of some sort. So is there cover if you need to leave your offices? Well, that depends whether you've got what's called passive cover or intervention cover. Intervention cover shortly is fire, flood. You have a fire in your office, you can't go there for a period of time, fine, you're covered. And most policies contain intervention cover. In fact, they all do, to be fair. Passive cover, however, is something slightly different and potentially includes cover for COVID-19 and acts of government. However, it's normally an extension to your policy, the basic policy will only have intervention. So you need to check your policy to see you have any type of passive cover. Now, obviously, if you do have it, there will be limits on how much you can recover under the policy, and you still have to prove that you have lost something as a result of having to leave your offices. So I suppose typically that would be the purchasing of additional laptops. I suspect for construction companies, those very large photocopiers that you use, we can't go to your office, someone may have to buy one. It's that sort of loss. Let me just have a quick look at force majeure. Again, everyone keeps talking about this, but I just thought I'd put this in. So coronavirus has undoubtedly caused delay to contractual obligations. I don't think there's any doubt about that. Contracts have been delayed, etc. But if a contract contains a force majeure clause, this excuses one or both parties from performance of the contract if certain events occur. But force majeure has no fixed interpretation in English law, so each case will be individually considered by the courts unless the circumstances are specifically set out within the force majeure clause. Now, importantly, in most JCT contracts, they're pretty silent as to force majeure. Just saying subject to force majeure in a contract means you have to go to court to get it interpreted. So businesses who think they could be affected by the pandemic should check the force majeure clause to see if it covers the circumstances we find ourselves in. As said, JCT contracts, very, very light on force majeure. However, let's learn the lessons that we've learned going forward. So when you're now entering into new contracts, you must, I would have said, have to consider whether to include a force majeure clause appropriate to the type of business locations in which it operates, so that reference is made specifically to pandemics and to epidemics. The clause should also include potential government reactions to outbreaks, such as quarantine measures in large cities and the closure of public transport, etc. Now, shipbuilding contracts for many years have decent force majeure clauses. They include requirements of government authorities, acts of princes or rulers. Well, the princes is slightly over the top, but there you go. And import or export bans or restrictions. I'll read you the full clause. Acts of God, acts of princes and rulers, requirements of government authorities, war or warlike condition, civil commotion or riots, mobilization, sabotage, strike or lockout, quarantines, flood, typhoons, hurricane storms, or other extraordinary weather conditions not included in normal planning, earthquakes, tidal waves, landslides, fires, explosions, collisions or stranding, import or export bans or restrictions, prolonged failure, shortage or restriction of supplies. How useful would it have been had that been in some of the JCT contracts at present? But it's not. I was asked a question the other week as to whose responsibility it is putting a force majeure clause in. Well, I am quite sure, well, I would hope that JCT will amend their contract to include a more vigorous force majeure clause, but there is nothing to stop you inserting one as an appendix to the JCT contract. I think we need to learn the lessons of what's happened and improve the force majeure contracts within JCT contracts. The doctrine of frustration. Well, where there is no applicable force majeure clause, another avenue might be involved the doctrine of frustration. That shortly is a court remedy again, so you'd have to court. Contract may be brought to an end where something unforeseen occurs after the formation of the contract through no fault of either party, that has the effect of making it commercially or physically impossible to perform the contract. Now, you could argue that the pandemic has frustrated the contract, but courts are often unwilling to find that a contract has been frustrated because it terminates the contract. That's it, over and done with, end of story. And courts are very reluctant to end contracts that parties have voluntarily entered into. Again, I repeat, it would be much better when you're now entering into new contracts that you put in a clause which specifically refers to events such as pandemics, rather than trying to use general law principles such as the doctrine of frustration. So, the insurance market's approach. Well, did the insurance market come running to our aid in our hour of need? No, it didn't. That's it. The approach shortly is COVID-19, oh, nothing to do with us. However, what potential cover might you have in respect of delay, cancellation of contracts, etc.? Well, obviously, business interruption clauses. These are the ones that are causing the most heated debate at the moment. Because people bought an extra to the policy, an extension to the policy, to cover notifiable diseases. And yet the policies haven't responded. That's what's caused the anger. There will be some policies, of course, where there is no cover for notifiable diseases because it was an extension to the policy. But there are many that do contain notifiable disease clauses, and broadly these fall into two categories. Firstly, an outbreak of a notifiable disease at the premises, and secondly, an outbreak of a notifiable disease within a 25-mile radius of the premises. Those are roughly the two different types. But you need to check all of your insurance policies to see whether you have got notifiable disease cover. As said, it would have been an extension. And people are angry because they paid additional money for that extension. You might also want to check your policies to see, and there are some policies that do this, if there is cover for delayed receipt of essential supplies. Check your contractor's all-risk cover. Again, they vary enormously depending on what you instructed your broker to do at the time. You instructed him to place the most basic cover, so you just get over the JCT hurdles, then you probably haven't got any notifiable disease cover. However, you may have said to your broker, get me the very best cover I can get. I have one client who pays regularly over £1 million for his insurance cover. And undoubtedly, he has said to his broker, get me the best you can. You may well have something in there regarding notifiable diseases. As I previously discussed, have you got cover for being excluded from your office? Now, what will assist? Well, this is a slightly double-edged sword. The government declared COVID-19 a notifiable disease. That's helpful, but it also keeps talking about the disease being a pandemic. That's not so helpful. In any event, the insurance market at the moment is simply saying, we're not paying. Because what they are going to argue, or one of their arguments at least, is that this outbreak was not within the reasonable contemplation of the parties when the insurance cover was taken out. Now, I've got a little sympathy with that. If you took out your policy in the 1st of January this year, which would be a normal renew date, COVID-19, not really talked about at all. Nobody had heard of it, particularly. Certainly wasn't called COVID-19. So what insurers say is, well, how could we possibly have insured that? We didn't know anything about it. But they've been quick to react. So unless you realistically took out your policy before, I would say, the middle of January, then you will now find that there are restrictions in the cover now being offered, and there will be very significant exclusion clauses in relation to viruses, pandemics, notifiable diseases in just about every new insurance contract. Now, I'm not saying it's a lost cause by any stretch of the imagination. If you took your policy out after the middle of January, you may well have just been fortunate but certainly I would have thought by mid-February, you're probably very unlikely to have any cover. Now, mitigation, and this again is important. If you are fortunate to have policies that include some kind of cover for pandemic and notifiable diseases, then remember all insurance policies, no matter what type you've got, require you to mitigate your loss. This means that you can't just close your office and walk away, even if you have cover for passive, if you have passive office cover. You must wait until the government says you must close your office before you actually do so. If you take steps voluntarily to do it, then you may find some difficulty. Now, in terms of business interruption, you must still continue to operate your business to the best of your ability. You cannot just simply say we're covered, therefore shutting up shop. That's not how it works. You must continue to operate your business to the very best of your ability, admittedly in difficult conditions, in order to minimize the claim that you may be able to make on your insurance policy. So, working from home, etc. All of this you need to be doing. Now, notification. This is another important point. And unfortunately, when I'm saying this, I'm thinking to myself now, I'm saying this and it may already be too late for some. You must inform your insurers as soon as possible that you will be making a claim. Now, at this stage, it is probably too early to make, I say make claims. It's not too early to make claims. I want to make that clear. But to put a number on your business interruption policy. But you will need to be able to substantiate the fact that your business has suffered loss as a result of business interruption, and everyone will probably need at least 2 or 3 months figures in order to be able to clearly demonstrate that they have suffered loss. And there will be lots of arguments around that loss. However, please, if you have got a potential business interruption claim, make it. It will probably be rejected by insurers at present, and your answer to that is, thank you, don't think you've interpreted the policy correctly, we'll be seeking legal advice, or we will wait the outcome of the FCA test case. But make the claim. Because if you don't, insurers will have an argument, as it's normally a condition precedent in most insurance policies, that late notification means your claim is to avoid your claim. And nothing in the Insurance Act of 2015 changes that. So you need to be communicating continually with your brokers to ask them what you should be doing in the current circumstances. If you have gone direct, which one of my clients did with a company that's got farmers in the middle of the word, was told very simply when she tried to make a business interruption claim, well, if we paid you, we paid everyone. Now, that's really not the correct approach. Make the claim, put it in writing. And you should be guided by the advice as to what you can claim for, when you should be claiming it, and you should be speaking to your brokers at every opportunity if you have one. If you haven't, and you're getting that response from your underwriters, make the claim anyway, put it in writing. Just one other point that's come up, if you shut your offices or sites, and I know that many sites were closed, you must again tell insurers and keep them updated. Most policies contain a clause that cancels cover if premises, sites are not occupied or worked on for more than 30 days. So make sure that if you're having to close sites or had to close sites, that you notified your insurers to tell them we're having to shut this site, etc. Okay? It's particularly important for office premises. Certainly with ours, we've had to tell our insurers, look, we're not working from our office at the moment, we're all working from home, etc. Because normally, as I said, you're not occupying it for 30 days, your cover lapses. Just a quick touch on travel insurance. It's now very unlikely that travel insurance will cover cancellation of delays as a result of the coronavirus. Again, exclusions, etc. will have come in. But if you were fortunate to have a travel policy which you took out in, say, January this year, then you probably do have cover for cancellation due to the coronavirus, etc. But the trick with all of that is to make sure that you do not, under any circumstances, voluntarily cancel your holiday flights, etc. Because if you voluntarily cancel holidays when you didn't have to, insurers will say, well, you did that, you didn't have to, that's your fault. Okay, so in terms of airlines, wait till they've cancelled your flight. Or, and in particular, listen to what is said by the Foreign and Commonwealth Office. They give the definitive advice as to whether or not you should be travelling to a specific destination. The FCA don't go. You can turn around to your travel provider and say, look, the FCA say I can't go, I'm not going. Because it's also, bizarrely, a double-edged sword. If you do go, and the Foreign and Commonwealth Office have said don't go, and something happens to you, insurers will turn around and say, well, the Foreign and Commonwealth Office told you not to go, why did you go? So, key to all this is do not do anything voluntarily. The insurers will say it was your decision to cancel, not something you were forced to by the United Kingdom government, in particular the Foreign and Commonwealth Office. So there has been a huge outcry, and I don't think I've seen in newspapers more commentary on insurance policies ever in my life. And there has been considerable anger directed against insurers in relation to their, in particular, failure to respond to business interruption claims. Now, at one stage, it looked the government were having meetings with insurers, and it may have been that the government was certainly thinking about intervening and saying, no, you must start paying. But that seems to have all died a death, and the government isn't now going to do anything retrospectively to say to insurers, you must start paying. However, there has been support from other areas as well. And the Chairman of Lloyds of London is the third largest insurance market in the world. And within its walls, there are some of the most powerful underwriting syndicates in the world. And the Chairman of Lloyds has said that in relation to pandemic and contentious disease extensions, where such extensions are provided on business interruption or contingency cover, Lloyds would expect this to include losses relating to COVID-19. Now, the Chairman of Lloyds, whilst he is a very important person within the insurance industry, has no direct power, but it's certainly an interesting view for him to have expressed. Incidentally, if you are struggling to pay your insurance premium at the moment, I know many companies will be, normally if you don't pay your monthly premium, as you all know, just from your own car insurance, you get there saying, unless you pay us within 7 days, we're going to cancel your cover. That shouldn't really be happening now in relation to your insurance policies. Lloyds expects underwriters to ensure they do not automatically cancel policies for consumers and small and medium-sized customers by reason solely of the application of a non-payment of premium clause for a period of non-payment of up to 60 days. So you shouldn't have had your policy cancelled simply because you weren't able to pay, certainly for a period of 60 days. Now, the FCA, I will come on to their actions on the next slide, but we've now had some thoughts of barristers on the question of business interruption clauses, and in particular on the question of whether they should be responding to COVID-19. Geoffrey Gruder, QC of Essex Court Chambers, without a doubt one of the leading sets of barristers in this country, has produced a very interesting 3-page document. And he considers the following clause, which is in some insurance policies. Infectious disease, murder or suicide food or drink or poisoning. And under that, there is another heading saying loss resulting for interruption of or interference with the business in consequence of any of the following events. Number C is any occurrence of a notifiable disease within a radius of 25 miles of the premises. He goes on. However, subparagraph C, which I've just read, is in a different category. Coverage is not restricted to the consequences of an event actually occurring at the insured premises. Indeed, there need not be an occurrence at the premises at all. There is cover if loss is as a consequence of any occurrence of a notifiable disease within a 25-mile radius of the insured premises. No doubt this cover was introduced to provide an indemnity when the presence of a notifiable disease, even some distance away from the insured premises, causes a proven drop-off or even total cessation of trade. He goes on. By the 23rd of March 2020, when the government lockdown was ordered, there are occurrences of a notifiable disease within a radius of 25 miles of, at the very least, many of the premises are insured under this form of policy wording. After all, COVID-19 was a pandemic which was rampaging in most parts of the UK by that time. It is apparent that the figures for actual cases of COVID-19 from early March 2020, if not earlier, were drastically understated because of the absence of an efficient and effective testing program. He concludes that if you do have such a clause in your insurance policy, then you have reasonably arguable prospects of recovery. However, without a shadow of a doubt, the most significant development has been the FCA. The FCA is a regulator that has teeth. It is not like the water regulator. He sort of slaps water companies and says, oh, you must pay him back £250. The FCA has real teeth and regulates the insurance and banking market. I think its record fine is 39 billion to Barclays, so it has teeth. And the FCA has two main objectives. Its first is that there should be, banks, insurance companies should treat their customers fairly. That is one of its biggest mantras. But its second biggest mantra is certainty. It doesn't like situations where there is a great deal of controversy and uncertainty as to whether or not, as in this case, a number of insurance policies should be responding to this particular situation. So it has been proactive, and it is bringing a test case to court, where the court will look at 17 policies, which broadly speaking, as I said earlier, there's probably about 75, contain most of the clauses that deal with business interruption. Now, I will not go through the document in detail here. I will summarize its main policies. It's not actually that long a document, which I was very surprised about. It's some 15 pages. There's a link to it. Please do read it. But briefly, the document goes on to explain the background to why they're bringing the test case. This, by the way, is an agreement between the Financial Conduct Authority and a number of insurers who are listed in the schedule there. The main purpose is not, this is slightly odd, but it's not to determine whether or not an insurer has acted reasonably and fairly and generally in accordance with its regulatory obligations. What it is the FCA, as the conduct regulator of insurers in the United Kingdom, has been considering many of the policies in the market and is concerned that there are a significant number of policies where there is uncertainty created by differences of opinion expressed by interested parties as to whether the terms of policies require that claims in respect of some or all business interruption losses are paid. it goes on in the background to say the insurers have confirmed to the FCA their views that certain policies which they underwrite the policies and which were covered in principle for business interruption losses without the need for physical property damage may not cover losses resulting from the COVID-19 pandemic. So there we are. That's its rough background. That's what it's there for. There's a number of policies. Insurers have their view. Policyholders have another view. The FCA is saying we need to take this to court. We cannot have this uncertainty in the market. There is a mutual objective, and the mutual objective is to achieve the maximum clarity possible for the maximum number of policyholders, especially, although not limited to small, medium-sized enterprises, and their insurers consistent with the need for expedition and proportionality. Again, much of the anger has been caused because, of course, companies needed help and assistance now. They wanted it now. They don't want it possibly in 6 months' time. And therefore, the FCA have said, right, well, we'll do something about this. Issues to be determined, well, it's going to proceed under what's called Part 7 of the CPR, which is really where you go to the court and you say, here's a set of facts, court. Given that background, given that set of facts, this is the insurance policy. Does that insurance policy respond given this set of facts? Part 7 procedures are normally can be used in a number of ways. So say two parties have been arguing for years, they have a mediation and they agree just about everything, but they can't agree on just one point. That would be an ideal situation to say, okay, the Part 7 application to the court, say, look, we've agreed everything else, court, we've agreed these facts, we can't agree on what the outcome should be. Will you, court, decide? It's normally done on paper, there aren't normally witnesses, but I suspect in this case there will be some witnesses. But because it is proceeding on the basis that everything's been agreed and insurers and the FCA are cooperating, then I don't think that will be too much of a problem. What they say about the agreed facts will be agreed between the parties as soon as practicable. Should full agreement not be possible with all insurers on all agreed facts, the FCA will present all the agreed facts that have been agreed with all insurers, and for the remaining agreed facts, the agreed facts in relation to the majority of insurers, so as to further the mutual objective being to get clarity in relation to business interruption insurances. It's quite a detailed process for agreeing these agreed facts, and I'm not going to go through it. It really is very, very technical stuff. So when's all this going to happen? Well, first thing the FCA are going to do is file a claim form at court, and they say they will do this by the 9th of June. So they're going to file a claim form setting out their case. The insurers will then put in a defence. The FCA will then reply to that defence. And that defence and reply should be done by the 3rd of July this year. Now, in the background, of course, the FCA and insurers' lawyers have all been liaising with the commercial court, which is where this is heard. The commercial court judges, for those that haven't been there, are amongst the best in the country. They are business astute and know what they're talking about and will be familiar with insurance policies, etc. With a view to having a 5 to 10 day trial, probably to be heard, I would guess, towards the end of July. Now, with the best will in the world, I cannot see even a commercial court judge giving a detailed ruling. I wouldn't have thought much before the middle of August. I may be doing the judges a disservice here, simply because they are very, very bright people. But I think it's unlikely that we're likely to get a first judgment until the middle of August. And then there is room within the agreement for an appeal. So I do not think we'll probably get the definitive answer, because I have no doubt that this will go to the Supreme Court House of Lords, to give me much before, I would have thought, mid-September. So that's the likely timetable, etc. It is definitely worth a read. This the document I sent you a link to. It's not overly complex, and it gives you an idea of exactly what is going to be heard by the court and what decisions they've been asked to make. Have I got concerns about the process? Yes. Firstly, the FCA, in a letter to the market, the insurance market, on the 15th of April, expressed a view that, based on our conversations with the industry to date, our estimate is that most policies of basic cover do not cover pandemics and therefore would have no obligation to pay out in relation to COVID-19 pandemic. I have a funny feeling that the FCA may be bringing this because more or less they've been pushed into doing it. I could be doing them a great disservice there. Of course, they may well be saying, no, we need to get this sorted out. Of that, they're absolutely right. Insurers are going along because, frankly, it's unsatisfactory for them as well. They need to know which of their policies are going to be found to be responding, so that they can reserve appropriately for their losses. At the moment, they will probably be having to make huge reserves, when in reality, maybe only some of their policies will be found to have to respond. So they want certainty as well. I think there's two other areas where I'm probably slightly concerned. I'm not sure why there isn't a little bit of a representative group of policyholders. So people directly affected. There wouldn't need to be many. 2 or 3 policyholders who have this, one of the types of policies being analysed by the court. Perhaps they could make representations to the court, if nothing else, to make it clear to the court how much their business has suffered and how helpful it would have been had there been a more positive response from insurers on the business interruption point. Or so, if you like, so that the court can understand the pain that many businesses have been suffering as a result of these policies not responding. And I am also slightly surprised that the broking industry is not represented either. Okay, wouldn't need to be more than 1 or 2 of the leading brokers. They should be giving evidence, I would have thought, to the court as to what they thought the business interruption policies covered. Now, of course, there may be a perfectly good reason why neither of those parties are represented, and that could simply be one of costs, but I wouldn't have thought it was beyond the wit of the FCA to say, okay, we will pay your costs. However, all of that said, I do think this is a very positive move. We cannot continue, and it's no good for anyone, frankly, insurers as well, not knowing which of these policies should be responding to. And we need some certainty, and the only way to get that certainty is for the court to rule on these policies. That said, though, I still don't think it's going to be a quick resolution. I doubt whether a definitive answer will be there until the middle of September. Then the claims will have to be evaluated, etc. And of course, this at a time when many businesses simply want help and cash to ease the pain caused by the last 3 months of lockdown. Now that, ladies and gentlemen, was all I was going to say, apart from one thing I've just remembered. I'd just like to read you one little paragraph, which is probably my own view on whether these policies should respond. It's just one line in Mr. Gruder's opinion, and he says this, and I think this is, it hits the nail on the head. Nature does not work in watertight compartments, especially where notifiable diseases spread by viruses are concerned. And I think that hits the nail on the head. Thank you very much indeed, ladies and gentlemen, and I'm happy to take questions if anyone would like to.
Hi, John. Yes, we've had some questions coming in as you've been going through, some of which you've answered, so that's great. We've been asked if a force majeure clause is not included within the trade contract due to a bespoke trade contract, what relevant event could be argued to obtain relief from damages?
Well, as I said, force majeure clauses, it's very annoying. I don't know quite why corporate lawyers put these in. They just say force majeure. Well, as I said earlier, force majeure is simply, and it's a French word, it frankly means stop. There has to be a definition of it. Now, if the wording you need to be putting in future, and indeed amending standard trade contracts and everything else now, is to put in a decent force majeure clause. The one I read out from the shipping contract, yeah, it is almost certainly most relevant to shipbuilding contracts, but there are parts of it in there which could usefully be incorporated into any contract now. So, acts of government, closure by government of factories, of suppliers, etc. You could put a clause in there, and that should relieve you from damages without the need for you to go to court. Because if all the contract says is force majeure, except or something like that, well, that's about as much use as an ice cream in a sauna. What you need is to have a clause which clearly defines what events are force majeure events, and therefore, and that should excuse all parties from being able to claim damages from the other.
Okay, thank you for that tip on eating ice cream in a sauna. That's, again,
you're very welcome, Julie. I've tried it once, it didn't go
well. Following on from the above, could both parties agree to revised contract wording to include force majeure against COVID-19 or other under a DOV or other?
Without any shadow of a doubt, yes. If you've entered into, because of course there is always talk about the second wave, so you might want to now be saying to the other party, look, we don't want to end up spending thousands of pounds in court. Let's amend the contract to include a force majeure clause. Yeah, and you could add that as an appendix to the contract, both parties sign it. There is absolutely nothing to stop you amending the contract to include a force majeure clause now. Absolutely nothing. And indeed, my advice would be to do so. Right. We still don't know exactly what's going to happen. Hopefully we're now over the worst, coming out the other side. But there is always the chance of another spike or something like that. So yes, I would have thought it was eminently sensible for both parties to get together and go, right, let's put a force majeure clause in, and that should include acts of government and also import-export bans. It should also include closures by government. It should also include something including any delays caused directly or indirectly by COVID-19. Yeah, put that in.
Notifiable disease cover. Are we now at risk of, for example, the common cold causing delay through such claims?
No, notifiable diseases has a distinct legal meaning. I can't remember where it was defined. Sorry, can't help you with that one. But there is a distinct legal definition of notifiable diseases, and the common cold is not one of them. Notifiable diseases are, I think, called notifiable diseases or named notifiable diseases by either governments or the World Health Organization, and they are specific. So SARS, for example, was clearly a notifiable disease, as was MERS, and there are other diseases which are notifiable, either set out, I think that's the point, sorry, I do vaguely remember, either set out by government as a Legionnaire's disease is a notifiable disease, but not your common cold and not flu, no. That would never be covered, because it would never be nominated, described, or called a notifiable disease.
Right, so that's why there is a distinction between a pandemic and a notifiable disease.
No, not quite. Pandemic is a word that I'm afraid I wish hadn't been used ever, because that again has a distinct legal meaning, and it's not helpful in terms of insurance policies. No, I wish the government had just simply said, well, this is now a notifiable disease. That would have been much better. By using the word pandemic, you are opening, if you'll forgive the pun, a Pandora's box in terms of definitions of pandemic, etc. So, yeah, it's a very good question, because there will be considerable argument in court regarding the notifiable disease and pandemics. Insurers, I dare say, will try and run the two together. The FCA will probably be saying, no, that's not right. But it's a nice question, I agree. And I'm afraid I can't give you a definitive answer on that one, Julie.
Okay. Someone here has asked, there are existing technologies used in pharmaceutical manufacturing and food processing that kill 35,000 different types of issues and bacteria, including SARS, MERS and other COVIDs. As such, does this work in favour of insurers or claimants? If it could be deployed before a second wave, would this be a mitigation paid for by insurers?
No, what insurers would probably say, if you have got cover for notifiable diseases, as I said, you probably have to have got that last year or very early this year. I think what insurers would then say is they would put a clause in the policy or amend the policy to say this policy will only respond in the event that you have used one of those products.
Right.
So that's just going back to the site closure point that I made earlier. If you do have to close the site, yes, you need to tell your insurers, but they may well, but ask them, but you need to tell them as well what you have done. We've secured the site, there's a security guard there. They may come back and say, right, fine, you've secured the site, there's a security guard. Well, look, if the security guard has to be withdrawn from site, please let us know, etc., etc., etc. They may ask you to do something else. So I suspect when offices reopen, what they will be saying is, yeah, you will have your cover for various things, but you must have obeyed government guidance in terms of one-way systems, not cramming your offices, social distancing, etc. If you haven't, well, they may well have an argument for saying, well, the government told you to do that, you didn't do any of it, why should we be responding to your policy?
Okay. What happens if one party refuses to amend the contract on force majeure to include COVID-19?
Well, then you've got a difficulty, I'm afraid. If you're amending a contract, normally all amendments have to be agreed, no matter what you're amending. They have to be agreed between both parties. If one party flatly refuses to put a force majeure clause in there, then frankly, all you can really do is put it in writing and say, look, we want you to put this in. We've asked you to put this in. We note that you're refusing. We will hold you responsible for loss or damage, etc. There's something you could do. But it is very difficult. If one party doesn't want to amend a contract, it is very, very difficult to force them to do so.
Okay. Are force majeure, or so a force majeure clause relating specifically to COVID-19 related incidents, is it sufficient as a blanket statement, i.e. events arising from COVID-19, or do you need to address every possible scenario which may arise, for example, closure of transport?
Again, as I hope I've made clear, if you're drafting a force majeure clause, you need to make it as specific as possible, because otherwise you're going to have to go to court to get it interpreted. So regrettably, yes, you probably do need to go into as much detail as possible. Contracts, again, like insurance policies, also have to be certain, and so you should define as clearly as you can a force majeure clause. It doesn't need to cover absolutely everything. The courts aren't stupid, and clearly know what's happened recently, and therefore what may happen again. But yes, transport closures, lack of access to key materials, for example, import bans, export bans. You need to be reasonably specific, but I don't think equally you need to write war and peace. But probably more than a sentence saying anything caused by COVID-19. Yeah, that's probably too vague. So you need to go a little bit further than that. But as I said, I don't think we need war and peace. Okay.
Well, that's all the questions that we've had submitted today. So thank you very much, John, for answering all of those for us. Thank you, everyone, for attending this morning. And we hope to see you all again soon. John's got a couple of articles up, and he's also I'm doing a vlog later, which will be released out this afternoon. So keep an eye out for that. And stay safe, everyone. We look forward to seeing you again soon. Thanks, John. Thanks, everyone. We'll see you soon.
Thank you.